Assalamu alaikum. Welcome to exam tip 2. Today I'll be covering consideration from your contract law syllabus. There are basically three major aspects that will come in your exam paper, either jointly or separately. Before I move on to the three major aspects of the chapter, I would like to discuss the minor aspects of the chapter, which are still very important. The first thing is consideration must come from the promisee. And this is the core understanding, and this is the core area of the chapter. The first thing that you need to understand in this chapter is there is a promiser and there is a promisee. From the promiser shall come the promise, and against the promise shall come the consideration that must come from the promisee. Okay? In no circumstances the consideration can come first and then can come the promise. Okay? So the first thing is the promise would have to come first and then shall come the consideration. If for some reason in the facts given to you, you see that consideration has been provided first and then came the promise, in that case it's very much likely that that consideration is a past consideration, which is not a good consideration. That's the general rule. There are some exceptions obviously, but in this brief session I'm not going to detail those exceptions. The next thing that you need to understand is consideration must be sufficient, it need not be adequate. This is very important to understand as well. For there to be a valid consideration in the eye of law, your consideration must have some economic value. If the consideration doesn't have an economic value, no matter how beneficial it was for the other side, still no consideration in the eye of law. So in the form of mental peace, in the form of mental well-being, consideration can't come. It must have to come in the form of some economic thing. So if the consideration doesn't have any economic value, it's not a consideration in the eye of law. So these are the very basic aspects that you need to understand in order to start the chapter, and you should understand that there are like two types of basic consideration. Number one, executory consideration that you'll find in bilateral contract. Number two is executed consideration that you'll find in unilateral contract. Then I'll move on to the three major aspects. The first aspect is contractual duty owed towards the promisor. I would term this aspect as being the Stig versus Myrick aspect, because this aspect did come from the famous case of Stig versus Myrick. I hope that you all have read the fact of the case, and in this brief session it's not possible for me to go through the facts in details, but I will give you a general idea of the principle of Stig versus Myrick, which is very important for the purpose of the exam, obviously. So I have told you, like, there is a promisor and there is a promisee, right? So from the promisor has come promise 1, and from the promisee consideration 1 is supposed to come. Okay, and then if the promisor makes a subsequent promise, a new promise, that is like promise 2, in that case, if the promisee has to enforce this subsequent new promise, the promisee would have to give a fresh or new consideration. If the promisee doesn't give a fresh or new consideration, the promisee cannot enforce the subsequent promise with consideration 1. This is the principle of Stig versus Myrick, that famous ship case. There was captain, there were crews and stuff like that. I'm not going to detail that case facts in this brief session. Read the general principle of the case very well, and that's a very important principle. And then obviously there is a contrasting principle that we have got from the case of Hartler versus Ponsonby, that we all know of as well, where it was said like, so if there is like promise 1 and there is like consideration 1, sometimes with this consideration 1 you can enforce promise 2. Okay, given that the facts are like that. So if because of the facts and circumstances, as was the fact of Hartler versus Ponsonby, if because of the fact the court thinks that this consideration 1, okay, it might be considered as a fresh consideration, as a new consideration, even for the promise number 2, the subsequent promise, still this subsequent promise or promise number 2 can be enforced by consideration number 1. So that was a contrasting case, again involving some ship story, some captain and some crew and stuff like that. You need to go through the facts of Hartler versus Ponsonby very well as well. Then comes the most important area under this aspect number 1, that is the case of Williams versus Roffey brothers. And the doctrine that we have got from the case is called the practical benefit doctrine. It's very important for the purpose of the exam that you go through the practical benefit doctrine very well. In that case, it was very well established that when there is like promise 1, that is like P1, and there is like consideration 1, that is like C1, and there is like promise 2, a subsequent promise P2, okay, this P2 can be enforced by C1. Okay, in the absence of a valid second consideration, you can enforce promise 2, the subsequent promise, by the earlier consideration, that is C1. You can enforce P2 by way of C1, provided that the facts are like that. Provided that from the facts you can show that the promisor, okay, who has made the subsequent promise, has got a practical benefit because of the consideration that's been provided by the promisee, even if that is like consideration 1. Still. So in the facts, if you find like practical benefit is present in favor of who? The promisor, in that case you can argue this doctrine. Okay, but you would have to bear in mind that this doctrine is an exceptional one, and it would have to be rarely used by the courts, and the court is unlikely to entertain the doctrine if there is any presence of duress in the facts. So this is aspect number 1. The aspect number 1 was what? It was contractual duty owed towards the promisor. Very easy, right? Then aspect number 2, very important for the purpose of the exam as well. That's what? That's part payment of debt. The general principle was given in the case of Pinel's case. You all know this case by now. And the principle is very straightforward. Part payment of debt is not a good consideration. Okay? Suppose this, if like this is a fact, like there are two people, A and B, okay? B earlier took 100 pounds from A. B is not paying off the 100 pounds. A has promised B that, okay, just pay me 50 pounds and I will not ask for the remaining 50 pounds ever. So B has paid A 50 pounds because of the promise. And then after like 7 days, A is again claiming from B, give me the remaining 50 pounds. B is saying, what happened to your promise? A is saying that what you have done, you have just partly paid the debt. Part payment of debt is not a good consideration in the eye of law, in the eye of common law. So you would have to pay me the remaining one. Whatever I have promised, it doesn't have any value in the eye of law because you have just paid me part payment of debt. So part payment of debt is not a good consideration, even if the promisor has promised, respecting that thing. That promise cannot be enforced by the promisee in the eye of common law. This is the principle of Pinel's case. And this is a very strong and strict principle, okay? And some cases have applied the principle in practice, like Folks versus Beer, Reselect Move. There are 4 exceptions in the Pinel's case, okay? In these 4 circumstances, the promisee can enforce the promise made by the promisor, and maybe in the eye of law, he will be exempted from paying the remaining debt. The 4 exceptions are: firstly, if the part payment is being made on an earlier date than the due date. The second thing is if the promisor receives the part payment from a third party authorized by the promisee. The third exception is if the promisor receives something in exchange of the original debt, not in the form of money, but like something, some chattel or something like that. In that case, he can't enforce he can't like claim the remaining amount. And the fourth exception is if there is a group of creditors, okay, and if they have promised, in that case they can't further claim the remaining amount. So there are like 4 exceptions that I would advise you to go through, guys. And these 4 exceptions are very important, and try to find out whether or not any exception is present in the facts of the exam paper. So this is the second aspect, fairly straightforward aspect. And third aspect is promissory estoppel. The first thing to understand is respecting promissory estoppel. This is not a common law doctrine. This is an equitable doctrine. That's the first thing. The second thing to understand is like you'd have to read two cases very well. Okay, Hughes versus Metropolitan, and the second case is the Hytris case. You will have to go through the judgment of Denninger as he was then in the Hytris case very well in order to understand the principle of the case. I would suggest you to go through the facts of the case very well so that you understand the principle. What is promissory estoppel? The doctrine is basically an equitable doctrine. Okay, it doesn't have its root in common law. And promissory estoppel is like when the promisor is making a promise towards the promisee, and the promisee has relied on the promise. He has relied on the promise. Okay, and if the promisee can show that even if no consideration has been provided against the promise made by the promisor in the common law, if the promisee can show that it will be inequitable or unconscionable on the part of the promisor now to show his back towards the promise that he has made earlier, in that case, the promisor is bound by the promise and he will be stopped from going back to the earlier position. Okay, this is promissory estoppel. And there are some basic conditions that you need to study when you're studying like promissory estoppel, and you try to study these things in bullet points, and you try to detail those those bullet points in the exam. Like promissory estoppel can only be used as a shield; it can never be used as a sword. So it's a defense. It's not a cause of action. Okay, and the promise that is being made by the promisor must be clear. It must be made in clear words, in unequivocal words. Okay, there would have to be reliance on the part of the promisee. If the promisee can show detriment is not an element of promissory estoppel, but if the promisee can show that because of the reliance he has suffered detriment, this will make the case of the promisee stronger. Okay, and the promisor would have to show obviously that it would be unconscionable for the promisor now to show his back towards the promise that he has made earlier. So this is promissory estoppel. So there are basically three major aspects that you need to study for the purpose of the exam, and there are some minor aspects that I have also shared in this quick session with you guys so that you can go through those aspects very well as well. Always remember that the more case laws you cite, the more marks you get in the exam. So it's very important that you cite more case laws. You need to understand some facts of some very important cases, but you need not write those. Okay, just write down the principles. But in order to understand those principles very well and memorize those principles very well, I would advise you to go through the facts of those cases. And the most important cases, I have just told you about those cases, which are the most important cases in this chapter. So that's it for now. And like if you follow this video of mine along with the lecture sheet that I have given you in the class, I believe that you will get a fairly good mark in the exam paper. Thank you very much.